The honourable member for Nipissing-Timiskaming.
Thank you, Mr. Speaker. Mr. Speaker, I'm pleased to have the opportunity to speak today in support of Bill C-51, the Anti-Terrorist Act 2015. This important and timely legislation, as if we have heard from many of our colleagues, fills important gaps in Canadian law that relate to threats of our national security. This bill is comprehensive and addresses, among other things, improved information sharing so that national security and law enforcement agencies can more effectively share information relating to threats, improve security for air transportation, and strengthen the tools available to our intelligence and law enforcement communities. The Anti-Terrorism Act 2015 will help prevent, detect, and respond to terrorist threats and activities. There are two important prevention measures in the bill that I would like to speak to today, namely the terrorist propaganda seizure and takedown powers. Prevention can come in various forms, and this legislation has a number of measures that support this pillar, including improved information sharing. As we all know, international jihadist movement has declared war on Canada and our allies. As we have seen in Copenhagen, Brussels, Sydney, Paris, and even right here at home in Saint-Jean-sur-Richelieu and Ottawa, jihad terrorists are attempting to destroy the values that make Canada the best country in the world in which we live, work, and raise a family. Clearly, Canada is not immune to homegrown terror threats. Therefore, the legislation before us today also includes, in support of the terrorist prevention pillar, measures to address the radicalization of these homegrown threats. Bill C-51 proposes two provisions that would address the proliferation and availability of terrorist propaganda that can contribute to the radicalization of our youth and turn them towards terrorism. These new powers would be complementary to the proposed indictable offense of promoting and advocating the commission of terrorism offenses in general. Specifically, the proposal is to create two warrants that will allow for the seizure of terrorist propaganda. Terrorist propaganda would be defined to mean any writing, sign, visible representation, or audio recording that advocates or promotes the commission of terrorism offenses in general, other than the proposed new offense of advocating terrorism offenses that I just mentioned, or counsels the commission of a terrorism offense. Mr. Speaker, the effect of this change is to authorize courts to order the seizure and forfeiture of terrorist propaganda material, whether in tangible form such as a poster or in electronic form such as a website. Currently, there exists a shocking gap. The Criminal Code does not presently authorize the confiscation of terrorism propaganda that is produced for sale or distribution in Canada, or that is stored on or made available by a Canadian server. The first new warrant would be similar to the provision of the Criminal Code governing the seizure and forfeiture of hate propaganda in a hard copy format, such as in books or magazines. Mr. Speaker, terrorist use of websites and social media to recruit and radicalize youth to violence is a growing concern. Currently, police can only ask that a website host voluntarily remove the material, and usually this would only occur after a conviction. However, when the person who posted the material cannot be found because they are abroad or have posted anonymously, the removal of such offensive material is very difficult and may be available to the public for some time thereafter. The Anti-Terrorism Act 2015 proposes to authorize a court to order the removal of terrorism propaganda from Canadian internet services, even when the person who has posted it cannot be found. This proposed power is similar to the ones already exist for other materials in Parliament and is deemed harmful, such as hate propaganda, child pornography, voyeurist material, and most recently with the passage of Bill C-13, the Protecting Canadians from Online Crime, intimate images. Some of these provisions have been in the criminal code since 2002 and help facilitate the removal of such harmful content from the Canadian internet services, which in turn limit Canadian exposure to such harmful content. Courts must have the power to order the removal of such terrorist propaganda when posted online. That is exactly what this new takedown provision is designed to accomplish. Under this new provision, judges may order both the person who posted the terrorist propaganda and the internet service provider to remove the material that is terrorist propaganda. It is focused only on the removal of the material that is available to the public, so that even in the absence of a prosecution, police are still able to remove this material from Canadian servers. As I mentioned earlier, these types of warrants are not new to the criminal code. I would also like to mention that they are also not new to the international community. For example, the United Kingdom has similar powers in place since 2006, and Australia provides for the takedown of restricted online material such as terrorist propaganda through the Broadcasting Services Act. As an additional complementary amendment to these new tools, Bill C-51 also proposes changing the customs tariff to include the new concept of terrorist propaganda. This change would ensure that the Canadian Border Services Agency officers would be authorized to inspect and seize propaganda material. These new tools are not complementary to the proposed new offense of advocating and promotion and commission of terrorism offenses in general. They are also consistent with the Parliament's past approach relating to content we have deemed harmful to Canadian society. As I said, these tools are designed to help address the radicalization to violence of Canadian youth and assisting removal of terrorist propaganda material. I would like to quote Avi Bonanno, the President and CEO of the Friends of Simon Wiesenthal Center, who said, "It is especially significant that this new legislation will enable the removal of websites promoting jihad and related materials on the internet. Jewish communities are a favorable target of jihadists, and the provisions of this bill would do a great deal to help ensure the safety and security of all Canadians as we continue to fight this threat to Western societies." Mr. Speaker, I hope that all members of the House may heed these words and support these proposals and Bill C-51 as a positive step toward making Canada and the world a safer place. Thank you very much. Merci beaucoup.
Questions and comments? Question et commentaire. The honourable member for Edmonton Strathcona.
I'd like to put a question, Mr. Speaker, to the honourable member, thanking him for his speech on this bill. But I remain very puzzled, Mr. Speaker, at the member's comments. The Minister of Defence has been quoted as saying that none of the new powers that Bill C-51 accord new powers to CSIS. The new powers are only accorded to the courts. So I'm wondering if the honourable member can elaborate for us. Is he suggesting, would he agree with the minister, that in all cases where the CSIS officials take down material that is displayed publicly or on a website, or if they intervene directly in an activity where they fear that there are quote-unquote terrorism activities? Could he speak to that? Does he agree with the Ministry of Defence, or is he taking another position that the bill in fact accords specific powers, new powers, to our CSIS?
The honourable member for Nipissing-Timiskaming. Thank you, Mr. Speaker, and I thank the honourable member for her question. Quite frankly, what puzzles me, Mr. Speaker, is I don't know why the NDP are against safety and security for Canadians. This is not hard. These are measures that are going to make Canada safer. Back in 2001, when we had the first terrorist incident, there were measures passed similar to this. We simply think that third-party, non-independent expert oversight of our national security agents is the model. Furthermore, key powers of the new legislation are subject to judicial review and judicial authorization. So let's get on, Mr. Speaker, with protecting Canadians.
Questions and comments? Question commentaire. The honourable member for Winnipeg North.
Mr. Speaker, the Liberal Party has actually been fairly clear on the issue of this legislation in the sense that we support it and will be voting in favor of it in principle, primarily, Mr. Speaker, because we do believe that it is a step forward. But we have pointed out what we believe many Canadians share, and that is that there's this need for the government to do more in terms of protecting the rights and freedoms issue. It is something in which we take very seriously. As the leader of the Liberal Party, very clearly in addressing the House on the legislation, put forward a model of parliamentary oversight. Now, Mr. Speaker, my question to the member is, does surely to goodness he recognizes that other countries like England and the United States already have parliamentary of some form oversight dealing with these types of issues? The question specific is, given that other countries are doing it and there's such a high need for Canada to be doing more on the oversight issue, why would the government not accept a Liberal Party amendment that would ensure that there would be parliamentary oversight? This is something that everyone wants to have. Why not allow Canada to have that parliamentary oversight?
The honourable member for Nipissing-Timiskaming.
Thank you, Mr. Speaker, and I thank the honourable member for his question. As I said in my earlier remarks, I go back to 2001 when we had a first terrorist attack. The member might recall it was a Liberal government that passed the Canadian Anti-Terrorist Act back in September 11th, in response to the attacks of September 11th, the attacks in the United States. The expanded powers at that time were highly controversial due to widely perceived incompatibility with the Canadian Charter of Rights and Freedoms, in particular the Act's provision allowing for secret trials, preemptive detention, and expansive security and surveillance powers. Your Worship, the Liberal government passed this Act. The sky didn't fall. I submit this is legislation that is needed right now, 13 years later. The sky won't fall. We need protection, we need safety and security for Canadians, and we need it right now.